one of my favorite segments of our podcast, and I'm going to answer listener submitted questions. But again, you need to understand I'm not giving legal advice here. Question number 1. In Massachusetts, is it legal for a high school vocational school district to offer an ERISA governed long-term disability plan to its teachers? Well, let's talk about ERISA. ERISA is a federal statute that will govern, among other things, long-term disability plans. There are 2 exceptions to coverage under the ERISA statute. If you are working for a municipality or a government agency, then your benefits are not covered under ERISA. Or if you're working for a church-governed type employer, like Catholic Charities, for example. In those 2 instances, ERISA doesn't apply. The law would be the applicable state law. So in answer to this question, the high school district, in other words, it might be more likely than not, it's a county. So the county can offer a disability insurance plan, but it's generally going to be excluded under the ERISA statute and therefore would be governed under state law. So hopefully you understand now the difference between an ERISA-governed policy or plan and a state law-governed policy or plan. Got it? All right, question 2. I've been paying into my employer's short-term and long-term disability plan for years, and now I need to file a claim. I'm being told by them that my condition isn't severe enough. How can something be disabling enough to keep me out of work, but not disabling enough for benefits under my own policy? Well, that's a great question. And it goes back to the terms of the policy or the plan, because the policy or plan will define what disability might be. It might be an inability to do your own occupation, as that occupation is performed for your employer, or by the particular geographic area that you live in. Normally, it's that your occupation is performed by the employer. But again, it could be even the broader definition of how it's performed under the Dictionary of Occupational Titles. So we want to start with what the definition of a disability is. Secondly, we want to look to see if the policy requires that you have to submit objective proof of the diagnosis and the disability. And this is where games start, because the common reasons for claims being denied is that there isn't an objective basis of the diagnosis, or there isn't any objective basis for the restrictions and limitations. So that's common, for example, in fibromyalgia cases or COVID cases. They may say, okay, we agree you have long COVID or you have fibromyalgia, but we don't think it's severe enough or that it disables you, as that term is defined by the policy or plan, and prevents you from performing your own or any occupation. So how do you go about proving that? Case law is really clear that you have to establish generally evidence that you have certain restrictions and limitations that may preclude you from performing the material and substantial duties of your own occupation. Now, obviously, in the case of fibromyalgia, it can be hard to provide objective evidence of the diagnosis, but the court would expect that there would be on physical exam findings the tender points, and that there would be muscle spasm, and there might be fatigue. There's got to be documentation from your doctor that those types of problems are related to the fibromyalgia. Better yet, functional capacity evaluations or even CPET exams can be really helpful to provide an objective basis of the ultimate restrictions and limitations. And then, of course, you need to tie it together with a vocational opinion that says, look, in view of these certain restrictions and limitations, this person could not do the occupational duties required under the terms of the policy or the plan. I always, if we get an FC, want the doctor to sign off for it, or I also ask the doctor to complete some residual functional capacity forms. Now, these forms are forms that we Social Security lawyers have developed. I also do Social Security because I use these in my ERISA cases as a supplement to the attending physician statement form that the carriers request. When you look at those APS forms, you can see that they simply do not ask the right questions. So the answer to this question is, let's start with a policy. What's the definition of disability? What objective proof requirements do you have? Are there any subjective condition limitations? 2, we want to look at your medical records. We want to make sure that you're giving a really good history of your symptoms and functionality. Number 3, we want to make sure that any restrictions and limitations assigned by your physician have an objective basis to it, based on physical examination, based on the results of functional capacity evaluations. And then lastly, we want to document that in the form of a residual functional capacity form or even a letter from your doctor that addresses those functional restrictions and limitations. And remember, Lastly, from a vocational standpoint, we want to tie this all together to establish that the severity of your impairment or problems preclude you from doing the material and substantial duties of your own occupation or any occupation if you're at that stage. Got it? Well, I hope that diving into these questions helps shed some light in the complexities of disability insurance world litigation and claims, and it gave you some practical tools to better navigate your own situation. I want you to remember that winning disability benefits isn't easy, but with the right information and support, it's possible not only to win your claim, but to stay on claim. Got it? Thanks for tuning in to this week's episode of Winning Isn't Easy. If you found this episode helpful, please take a moment to like our page, leave a review, and share it with your friends and families. And of course, subscribe to this podcast. And as you know, I love those questions. At the beginning of each episode description, you'll find a link where you can send us your questions or comments. And I will probably feature them in a future episode because I want this to be an exchange of information between you and myself. Got it? So join us next week for another insightful discussion, and thanks for listening.